What happens to my Connecticut car accident case if I'm 51% at fault under Section 52572H? If you are found 51% or more at fault for a car accident in Connecticut, you cannot recover any damages under state law. Connecticut follows a modified comparative negligence rule that creates a strict cutoff once your fault exceeds 50%. This means you may still recover compensation if you are 50% or less responsible, but your award will be reduced by your percentage of fault. Connecticut General Statutes Section 52572H controls how courts and insurance companies assign fault after a crash. Under this law, each party is given a percentage of responsibility based on how much their actions contributed to the accident. Your total damages are then reduced according to your assigned share of fault. However, once you reach 51%, you lose the right to recover anything at all. This is known as the 51% bar rule, and it can determine whether you receive partial compensation or none. Fault allocation becomes critical because the difference between 50% and 51% is the difference between recovery and complete loss. Insurance companies often try to increase a claimant's percentage of fault to reduce payouts or deny claims entirely. Fault is determined by reviewing evidence such as police reports, witness statements, photographs, video footage, and vehicle damage. Judges or juries may also examine traffic violations, distracted driving, impairment, road conditions, and electronic crash data. For example, if you were speeding but the other driver ran a red light, the issue becomes which driver was more responsible overall. If you are assigned 49% fault, you may still recover 51% of your damages. If you are assigned 51% fault, you recover nothing. A lawyer can help challenge exaggerated blame and protect your ability to pursue compensation. If you are found 30% at fault, you can still recover 70% of your damages after the reduction. If you are exactly 50% at fault, you may still recover half of your total damages. But once fault reaches 51% or more, Connecticut law completely bars recovery. Shared fault does not automatically disqualify you, as long as your negligence does not exceed the combined fault of the other parties. An attorney can investigate the crash, gather supporting evidence, and fight unfair fault assignments. Insurance adjusters may twist statements, blame delayed reactions, or focus on minor traffic issues to raise your percentage of responsibility. That is why it is important not to admit fault or give recorded statements before speaking with a lawyer. Taking quick action to document the scene, obtain the police report, and seek medical care can strengthen your claim. You also must meet Connecticut's deadline for filing a car accident claim, which is generally 2 years from the date of injury. If you disagree with the fault percentage assigned, you have the right to challenge it through evidence, negotiation, or trial. A law firm can help ensure the fault allocation is fair and that your claim is not improperly denied. DeFronzo Petroskey, PC is a Waterbury law firm that helps accident victims dispute fault and pursue compensation under Connecticut law. Their attorney Dan Petroskey has represented injured clients in car accident cases throughout New Haven County for over 20 years. If fault is being contested, working with a lawyer and an experienced attorney may prevent insurance companies from pushing your percentage above the 50% threshold. DeFronzo Petroskey, PC can be reached at 203-756-7408 and is located at 255 Bank Street No. 2B, Waterbury, Connecticut, 06702, United States.